Good afternoon. My name is Jonathan Culwell, and I'm here with Allison Daley. I am an attorney in Denver, and I am also a board member of NAMI, Colorado. I, as well as a board member, volunteer on the Public Policy Committee, and I have engaged in a little bit of advocacy and a lot of volunteer time with the Colorado Bar Association. I as well take cases in guardianship, conservatorship, and engage a lot in mental health work, whether that's on behalf of an individual or families or people who would like to become guardians of an individual when that's appropriate. I'm here today to present with my colleague, Allison Daley. Allison is an attorney with the City and County of Denver. She's an assistant city attorney in the mental health unit. That unit handles mental health certifications, which includes involuntary medication, electroconvulsive therapy, and feeding tube administration, as well as involuntary commitments for substance use and extreme risk protection order litigation. So prior to her work with Denver, Allison was a legislative and policy advocate for Colorado Counties Incorporated, lobbying on behavioral health, human services, and criminal justice issues. Allison graduated from the University of Colorado in 2016 and holds an undergraduate degree from Boston University in psychology with a minor in public health. So we are going to welcome Allison. Thank you for joining us today.
Thanks, Jonathan.
So we're going to move right into this presentation today. We've got some slides to put up for you, and we're going to be talking about Colorado's red flag law, which is the extreme risk protection order law. You're going to find this in statute right next to the civil protection orders. So without further ado, I will share my screen and we will get going from that.
Great. I'll kick us off. So as Jonathan said, we're going to talk about extreme risk protection orders, and these do go by a lot of different names depending on the state. Some of them are red flag laws. They're also called gun violence restraining orders, firearm restraining orders, but in Colorado, they're extreme risk protection orders. And essentially, the big picture is that it creates the ability for a family or a household member or a member of law enforcement to petition the court to remove firearms from an individual. It became law just this year on January 1st, 2020. And as Jonathan said, it's located in Title 13, which is right next to the civil protection orders that folks can petition for in the courts on their own.
I will do my best not to jump ahead of my slides, Allison. So what are we talking about with this? Colorado has, and this isn't uncommon, Colorado has two different types of proceedings in this, and they're very similar. One is the ERPO, or Extreme Risk Protection Order, and that's going to be a 364-day order, basically 1 year. But the TERPO is for up to 14 days prior to the permanent order, if you will, permanent. It's temporary because it would allow a person to avert or avoid an emergency. And so we're going to be talking about both of these interchangeably today, and we're going to be using ERPO and TERPO because that's just kind of the parlance that we've caught on to, and we're comfortable with that, and I think it makes sense. So temporary extreme risk protection orders are, like I said, for up to 14 days. The burden of proof there is a legal concept you may be familiar with. That basically means it's the obligation a party has to prove his, her, or their claims or defenses. And in this case, a temporary a TERPO would be proven by preponderance of the evidence. And a preponderance is that it's more likely than not that the petition states something that's true, more likely than not that this person, as you'll see next, that the court can find that this person, a respondent, poses a significant risk of causing personal injury to self or to others. Temporary extremist protection order requires in the near future by having a firearm. And then another legal term down there at the bottom, ex parte, means without a party, if you were speaking Latin, which we don't do, but once in a while. It means that the individual who wants the temporary order because of a very near future risk of significant injury needs to do so without the other person able to present their own evidence. So they go to court with a petition on their own, ask the court, please do this right now. And that is how the TURPO proceeds. The court's required then to schedule a hearing within 14 days. I think we'll get into that a little bit later. It's not difficult to understand. But that within those 14 days, you have an extreme risk protection order hearing. And at the ERPO, the court can enter the court can enter a 364-day order. It is a 364-day order. At that point, again, the obligation a party has to prove, the burden of proof, their burden at this point is clear and convincing. So petitioner, not you necessarily, but petitioner has to state a series of facts or propositions that considering all the evidence, it's found to be highly probable and you have no serious or substantial doubt. Clear and convincing. One way that I kind of think about it is for a criminal standard, if it was mathematics, which it's not, you might think of preponderance of the evidence like 51% or more, and clear and convincing kind of like 75% or more, and then beyond a reasonable doubt is a criminal standard, and that's going to be the highest burden of proof we have. And again, no, I don't think that anyone would say that has to be 100%. So again, it's not mathematical, but you get the idea. And again, the finding here is that respondent poses a significant risk of causing personal injury, again, to self or others, by having a firearm. And this one is not ex parte. This hearing is adversarial, and it's evidentiary. So witnesses, documents, testimony, etc., all very important for that hearing on both sides.
So who can file for a temporary and an extremist protection order? So these are, like we said, one of the main parties is law enforcement. So a member of law enforcement, an individual officer can file on behalf of the law enforcement agency. But the other term is a household or family member. And this is defined in the statute, and it's defined pretty broadly. It includes persons related by blood, marriage, or adoption by the respondent, a person who has a child in common with the respondent, a person who regularly resides or resided with the respondent within the last 6 months, a domestic partner to a respondent, a person who has either a biological or legal parent-child relationship with the respondent. That would include step-parents and step-children, as well as grandparents and grandchildren. It also could include an acting legal guardian or someone who has acted as a legal guardian to the respondent before. And then also it's defined as a person who's in an intimate relationship with the respondent, regardless of whether they've been married or lived together. And intimate relationships are essentially also defined in statute. That would be pretty intuitive, a relationship between spouses, former spouses, past or present. It also includes unmarried couples or persons who are both parents of the same child. And in the petition, the individual has to attest that they are a family member, and that is an attestation that they can face. You could face punishment for lying about that, and this has actually happened. There was a case out of Larimer County where a petitioner lied about having a child in common with the respondent, and they did not, in fact, have a child in common. It was the officer that she was trying to get an ERPO with had an interaction with her own son, but they didn't have a child in common. So the case was dismissed on those grounds. There was also a case in Denver of a former father-in-law, and the court found that that individual did not have standing. So this is kind of used as a way to screen out some of the cases. But like I said, the household and family member is interpreted pretty broadly. The one thing that's interesting about Colorado's extremist protection order that sets it apart from other states is that we don't allow for mental health providers, coworkers, employers, school staff. None of those are appropriate petitioners. And I think some of the reason other states are doing that is that those are maybe potentially individuals who are coming into contact with folks who might benefit from having an extremist protection order. But in Colorado, we're limited to law enforcement and family and household members. All right, if you want to move to the next.
Allison, on that thought, yeah, I understand that you represent Denver Police Department, correct?
Yes. So our role is, and we'll get to this a little in a couple slides, is that we are by statute required to represent the Denver Police Department, or required to represent law enforcement upon their request. And we've interpreted the statute and worked with our partners there to mean that anytime that they are interested in filing a petition, my office, the Denver City Attorney's Office, represents them in that case.
Okay, but not family. You do get into this in another slide?
A little bit, but we don't typically get involved in the cases that are family or household members. To some extent, the Denver Police Department, as my client, has to get involved because there are statutory requirements for Denver Police to have to serve some of the paperwork. There's requirements for potentially if there was a search warrant in the case, which we will get into. There are situations where Denver Police gets involved, but they won't get involved as the petitioner, and so my office wouldn't be the ones that get involved. And we won't typically attend those hearings. We often don't even know that those hearings are happening. They're sort of happening within the court itself and not our office.
All right, let's skip forward then.
Okay, so there's quite a few filing requirements, and these are just the things that if you were to fill out a petition, all the things that you would need to include information about so that the court can determine that they're going to hear your petition before them. So as I mentioned, it's an affidavit signed under penalty of perjury. So perjury charges have actually been filed against the woman in Larimer County who lied about the attestation that she was a family member or had a child in common with the respondent. So that it is signed and notarized. You have to set forth allegations that support the issuance of the order. And we'll go more into depth about what it means and what are those allegations and some of the things that the court's including in a few slides. You have to describe any firearms that you believe that are in the possession, in respondent's ownership, possession, custody, or control. And the petition asks if you know where the location of those firearms is. It asks you to disclose those locations. You'll have to attest whether the respondent is required to possess or carry a firearm as a condition of employment, whether there are any existing protection orders in place between the petitioner and the respondent. And that's a fact pattern we see a decent amount of times, is that there are protection orders often in place or there have been in the past, depending on the fact pattern, like domestic violence. Whether there are any pending lawsuits, complaints, petitions, or other actions between the party. And the statute explicitly says that the court may grant an extremist protection order regardless of whether there is that pending action in place, and the court is not allowed to delay granting relief just because of that pending lawsuit. And I think that this is an interesting point because it really shows that the court did, or that the legislature did sort of contemplate that this could be used as a tool, as a potential leverage in an ongoing divorce or a domestic relations case, because I think they knew that if one of the parties did get an ARPA against the other party, it might have impacts on things like custody. And so I think that's why this was put in there. But it does also it does flag though for the court that it can't deny the petition just because of that fact pattern. There's also, if you are a family or a household petitioner, you have to, as I said, attest that the petitioner is actually a family or a household member. And then for law enforcement petitioners, which are the ones that I deal with, the statute requires that law enforcement also file a sworn affidavit for a search warrant. What's really happened in practice is that there are situations where individuals have handed their firearms over voluntarily prior to an extremist protection order hearing. Sometimes they might have lost their firearms as a result of a criminal charge. So in most situations, we actually don't need to get a search warrant for the firearms because Denver police is already in possession of those firearms for one reason or another. And so we've kind of gotten around this requirement by just filing a statement that just indicates to the court that there doesn't need to be a search warrant at this time, just because most people have been willing to just give them up. So we've done search warrants in a handful of cases. I'd say under 5 out of we've done about 20 cases, and I'd say under 5 search warrants. So they're not super common, but they have come up a few times.
Allison, I have a couple of thoughts that I just want to touch on here with this slide. And I should apologize. I was looking at a slide ahead of us on our last slide. So yeah, you will get to those other things. I apologize for that.
No problem.
But one thing that's really curious to me is what's the point of asking or putting on the petition whether a respondent is required to possess or carry a firearm as a condition of employment? Why does that matter?
I think that's a great question. I would say in my personal practice of the law, I have used that in the situation where there was an individual who was required to carry a firearm as a condition of their employment, and it did ultimately, with some other assurances of establishing safety and the person agreeing to go to treatment and different things, we actually did decide to move forward with the extremist protection order, in part because it would have resulted in the loss of this person's job. And I think if you're dealing with somebody who has mental illness, having them become an unemployed individual is not going to help their situation and isn't going to really improve what their situation is. And he was somebody who had threatened harm to himself. And so I think the knowledge of that allowed us to think more strategically about what the best case scenario was for this individual. But I'm not sure if the court cared at all that this individual had that circumstance. I don't really know what the purpose of asking for it is, or how the court's supposed to weigh it. Are they more likely to grant an ERPO if you are required to carry as a part of your employment, or are they less likely to grant one? I think there's arguments on both sides that you could say we should grant one because they carry firearms more often, or you should say we should deny it because we don't want them to lose their job. So I think it could go either way. It's an interesting factor.
Thank you for those thoughts. Obviously, I don't expect you to know every jurisdiction and everything and the minds of each, but we appreciate you sharing your experiences and your personal thoughts here today. One thing that I want to point out is that the statute is pretty clear about that the ERPO can be, or a TERPO or an ERPO can be granted whether there is a pending action, and court may not delay granting relief because of the existence of a pending action. And there's been something of a pattern of filing criminal charges at the same time as on the same facts as the extremist protection order basis. And so I, as a mental health advocate, an individual advocate, and sometimes respondents counsel, I'm concerned that we may be criminalizing mental health disorders with this new law. So plenty to work out. I think that's a concern, but as far as the filing requirements, we do have those here in front of us. And that's what the law is right now. But if we move on to the next one, let's talk about your office's involvement, the slide that I thought we were already on.
That's okay. So according to the statute, it says that if a petition is filed by law enforcement, the officer or agency shall be represented in any judicial proceeding by a county or city attorney upon request. So when we decided to do the implementation of this, the city attorney's office worked with Denver police and just determined that anytime they're the filing party, they want our office to represent them. And that's a very practical sense. We are able to access the court e-filing system and we can file the documents for them. It also allows them, I think, the opportunity to ask us about different fact patterns. Sometimes we can strategize with different individuals to discuss whether or not an ERPO is actually even a good fit. We've had a couple cases recently that didn't result in ERPOs because they were cases that involved prior felons who had firearms, and those people are already prohibited from having firearms. So an ERPO wouldn't actually add anything to the protection. And so I think having us work with them from kind of the moment that the petition is getting drafted helps us be a little bit more creative and to determine if an ERPO is really the most appropriate tool to use. And this also works ultimately when we go to the hearing itself. So the assistant city attorney is the one who calls witnesses and presents all of the evidence. So at a temporary extreme risk protection order hearing, when that burden of proof is the preponderance of the evidence, we're the ones who, we call the witness, we present any evidence that we have. We might have exhibits, we might have video or photos, and that is all stuff that we present to the judge, and we do all the questioning. It's interesting because in civil protection order hearings, there aren't attorneys typically, and so the judges are often actually the ones that do the questioning themselves. So it's a really interesting, they have kind of different relaxed rules of evidence. So we've been really, I think that's something we've been still trying to work with, is what are the rules of evidence in these hearings, especially when there's not another party that's on the other side of things. And so typically our witness for the TERPO hearings is just the main kind of one petitioning detective. And then once we go to the full hearings later on, we usually have several witnesses, different police officers, family members. But the first hearing is typically just one officer. And so our office is the one that handles the full adversarial hearings. We also turn over evidence to responding counsel. We kind of manage the whole hearing.
And just to clarify, I think I heard you correctly. You said that there typically are not attorneys with civil protection orders. They could be there if that was something a party wanted to do. But in this case, we're seeing that attorney involvement is really quite important.
Yeah, absolutely. I think this is a unique situation, and that's what makes these restraining orders different, I think, than other restraining orders, is that we are talking about firearms, and I think that's one of the reasons they wanted to have the legal protection. But typical civil restraining order hearings aren't going to have attorneys on both sides typically. And yeah, it'll often be just the judge, and they'll ask the questions of the parties and kind of weigh the evidence on their own. Those restraining orders also last a lot longer than extremist protection orders are, potentially. So there's some similarities, and then there's also some big differences. And Colorado is unique in its appointment of court-appointed counsel for respondents. In most states, if not all the other states with ERPOs, there is not a court-paid counsel appointed. So an individual could hire an attorney if they wanted, but most often you might end up in a situation, my guess is you're ending up in a situation where most of the parties aren't having attorneys.
Great, thank you. So let's move on to what can the court consider? So again, this relates back to the burden of proof. It relates back to the finding by preponderance, or at the ERPO hearing by clear and convincing evidence. These are the things that are in statute that the court can consider. And that's going to be a recent act or credible threat of violence against self or others. That does not require an act or a threat that involves a firearm. It could be, it must be recent enough to cause the court to raise an eyebrow. It must be something that gives the court concern about recent. And then looking for, some type of emotional, volitional instability, some reason they would want to, they would be likely to use a firearm. But again, it doesn't have to involve that. Another one would be a pattern of acts or credible threats of violence against others or against self. That is in statute. It has to be within the past year. Probably every time the Broncos lose, the person becomes inconsolable is probably not a good reason to take their firearms away, or at least not by itself. But if a person's gotten in multiple verbal confrontations with service personnel, there's been road rage, there's punched more than one hole in the wall. We're getting closer now. So some type of pattern, a violation of a civil protection order. We've been talking about that for a while. That can be important. And, you know, it's interesting, the Civil Protection Order statute I don't think it necessarily requires that a person not have access to firearms. It can be kind of carved and limited and kind of specific, but that this statute, the ERPO statute, says a violation of a civil protection order. So whatever that is. I don't understand the language around previous or existing extremist protection order and any violations of that. I can tell you what I think it might apply to. So I'm not sure. So looking at that, I'm not sure how one can violate a previous extreme risk protection order ever. If it's a previous order, it's not currently in place, you're not ordered to do anything by that. So you're not violating anything. If it's currently in place, then why are we back in court asking for another one? My only real guess there is that while it's not mentioned in statute, if there was an extreme risk protection order or something very similar under a different name from another state, and you are now in Colorado and violating that order, maybe then Colorado would recognize that other state's law and that you're in violation of it, and consider that to be part of the whole story as to whether an ERPO should enter. I think it's fairly obvious that if you have a history of domestic violence crimes, that would be, you know, helpful to the court. I think similarly, if you don't have a history of domestic violence crimes, that would be helpful to the court. But I'm not seeing on this issue that it has to be within the last year. It's just a history of. And then the last one is respondent's ownership, access to, or intent to possess a firearm. It does not go without saying right now that this cannot be the only piece of evidence that a person petitions on. That is a constitutional right that we have state as well as federal. And so I think what's important, what the court's looking for there is, you know, I'm so angry, I could kill you. I hate my life. I am gonna go buy a gun and I'll come back and I will shoot you, right? I mean, however those facts show up, not like one little sentence there that causes concern, but that it's something credible and with an intent to possess, so.
And I think related to that, one of the facts that we discussed when we were implementing the statute and running through kind of fictional fact patterns, we talked about the idea of, can we do an ERPO against someone who doesn't actually own any firearms ever at all right now? They have no access to them, they don't possess them, their family doesn't possess them. And we look at this language as sort of, I think the legislature trying to say, we want to be able to prevent people from doing it. But I also think that the city, that we feel strongly that we want it to be somebody who has strong intent to possess a firearm and not just this kind of vague, like, I'm going to shoot you, I'm going to go get a gun and shoot you. Like we were talking more about specific fact patterns. Like if somebody bought tickets to the gun show, as the expression goes, like if somebody is going and they have this plan to go and acquire firearms, I think that's a different fact pattern than sort of vague intent. And I think that's why we do want to, it's such an interesting one because it is regulating a legal activity. And so we do want to be cautious about that. I also think the one thing I wanted to flag too for the pattern of acts, it is in the statute that it has to be within the past year. And that always puzzles me a little bit because I think when I think of patterns lasting a long time, like long histories of domestic violence, long histories of abuse, like whatever it is. And so it's interesting to me that the pattern is limited to a year when I think patterns typically are a little longer. But I'm not the legislature, so I didn't come up with that language. But that one always seems interesting to me.
You know, I think just a little counterpoint on that issue is that, you know, when we're concerned about, you know, mental health issues, someone may be decompensating or something, and we're looking at patterns, we're seeing escalation, right? We're seeing things go up or becoming more and more and more common. A little bit of odd behavior, disorganization, anger, everyone has those moments. Stress, you know, our current pandemic, the stress around our federal administration and the election coming up, these things are very understandable. But yeah, if someone's developed a pattern over years and years and years of time that they just are difficult to get along with, um, I think what the pattern would show is that they're difficult to get along with. But if it's escalating, I think it might show maybe that they're going to become more dangerous.
Yeah, I think that's definitely true.
All right, what's next? Let's see. There we go. So what else can the court consider, Allison?
So there are quite broad considerations. And I think that kind of what Jonathan brought up in the last slide is there's a lot of questions about what's required. Like, do we just need to meet one factor? Do I need to show 5 factors? Do I need to show all the factors? And certainly, as Jonathan pointed out, just possessing a firearm can't be enough. That cannot possibly be enough. So there's a lot of other things. So as we talked about, there's also the court has to look at credible threats of or unlawful or reckless use of a firearm. And that's a fact pattern we see pretty often if people are at the point where they're getting an ERPO. That's a fact pattern we see that we use a lot in our cases. The court has to look at whether there's a history of use, attempted use, or threatened use of unlawful physical force against another. Again, that doesn't require it to be physical force with a firearm. It could be any type of force, as well as a history of stalking another individual. Interestingly, the statute actually allows for us to allege that there's evidence of an arrest for any Victim Rights Act crime or a cruelty to animals arrest. It doesn't require a conviction, which is pretty interesting because I think that an arrest doesn't require the same burden of proof. We don't have to necessarily take someone to trial to arrest them, all those things. There's just a whole lot of due process that's lacking at the arrest phase compared to the conviction phase. And so I think it's interesting. I think one of the reasons the legislature added in that arrest section is some of the links between animal cruelty and future violence, Victim Rights Act crimes due to, obviously, as stated, they do have victims to them. And so I think that's why they're a little bit more broad, but I do think this is a really interesting inclusion. We also have to consider evidence of alcohol or substance abuse. This is, again, really broad, and it potentially encompasses otherwise lawful behaviors. So it's something that on its own shouldn't really be enough, potentially either. But we have seen in, I would say, almost every case that we've had, the combination of somebody being very intoxicated and having a firearm, and sort of how it becomes dangerous, how it becomes unlawful or reckless. It is reckless use of a firearm to use or discharge a firearm when you are intoxicated. So that's a fact pattern we see really common. That's, I would say, in 90% of the cases that we've had, that's part of the fact pattern. There's also the question of whether the respondent is required to carry a firearm for work, as well as any evidence of recent acquisition of firearms. So if somebody has purchased them in the last few days or weeks, that might be an indication that that behavior is escalating, like Jonathan pointed out. And then there's also the requirement, which this one's really interesting, is that the court is required to consider any evaluation available to the court concerning mental health or chemical dependency. And we really don't know how that is meant to be interpreted. We don't really know what the legislature wanted. We don't want to interpret it so broadly as to be any single appointment you've had with any mental health clinician in your entire lifetime. That seems really unrealistic and broad, but we don't really know what it's supposed to be limited to also. So we've used it to get sort of maybe limited access to records for somebody who was put on a mental health hold. That led to the ERPO, but we really don't know what it's supposed to be sort of in a big picture sense. There have been cases, there was a case in one county where the city attorney, or where the county attorney filed the extreme risk protection order case into a mental health certification case within the same case number. The court removed it and opened a new case, however, so we just don't really know what the state courts are looking for as far as what that evaluation means.
As respondents counsel, I would be concerned with the word available. Evaluations for mental health and chemical dependency are typically going to be protected with privacy protections, whether that's under HIPAA or a 42 CFR Part 2 protection, or maybe just under the physician-client privilege. And I will always argue on behalf of my client at their direction that those are private and should not be allowed in. So yeah, I completely agree with Allison here that it's unclear what this means, and it's a new law, and so I think this is a matter. Some of this is a matter for appellate law. But at the same time, I will also just be a little bit equivocal here and say that if an evaluation is available and it does indicate that there is chemical dependency or mental health issues, I think those are relevant things toward whether or not the person poses a substantial risk. So what happens when a temporary extreme risk protection order is granted? The court schedules another hearing, like I said, within 14 days to consider whether to grant a 364-day order. The statute reads that the court must appoint an attorney to represent the respondent upon the filing of the petition and not wait until after the temporary extreme risk protection order hearing and service of a warrant. Certainly that depends on how the court takes the petition. If it takes it the same minute that it hears that emergency hearing, if it has that room in its docket, then there's some practicality there. But I think in general, there might be a little bit of time to at least appoint an attorney right away certainly before the service of any warrant or service of the TRPO. And then we will get back to the concept of respondents counsel becoming competent within 14 days or less. But that the next thing that happens when a TRPO is granted is that law enforcement serves the order, serves the notice of hearing, and serves the appointment of counsel to the respondent or on the respondent, and informs them of the firearm relinquishment requirements. In other words, they ask them for their firearms. Allison, remind me, when a family petitioner receives a TRPO order and has to serve, do they have to serve it with law enforcement, or can they do that with a private process server?
I believe the statute requires it to be law enforcement still. And that's how he's gotten involved in some of these.
Can they serve that themselves though?
Can the family member, household member serve it themselves? I don't think so. I think it's required to be law enforcement. Like law enforcement from the jurisdiction of where the person lives. So
yeah,
if you were a family member and you lived in Denver, but your brother lived in Grand Junction and it was granted, then the law enforcement agency in Grand Junction would be the one who would serve it, there's a lot of interesting dynamics that come up with the service piece.
Well, I think that I would agree with you that the petitioner cannot cannot serve an opposing party. And I just wanted to point that out for people who might be watching this to kind of understand this on a personal basis. And I think that in this case, I'm just going to look real quick because I think, as you were saying it, I agree with you that I think the TRPO has to be served by law enforcement.
Yeah, and I think part of that maybe is maybe a little bit of a safety like provision and also maybe somewhat to do with the firearm relinquishment process, that law enforcement can legally take custody of those firearms in a way that maybe a household member shouldn't. But I'm not sure.
No, that's actually a very, very good point. That it's not even about the safety. I mean, of course the safety, but that who's an appropriate person to hold on to the firearms after they've been surrendered or relinquished? Being served with an order by a uniformed officer is always going to have a gravity that an individual wants. Even an attorney or a doctor, it's just always going to have a little more heft to it. So that's probably for everyone's protection. But then handing those firearms over, probably needs to go to someone who has the authority to hold them. And in the statute, we aren't going to get into this, but in the statute, they either need to be given to an FFL or to the police.
And an FFL stands for
I'm sorry, a federal firearm licensee, someone who is authorized by federal law to hold on to firearms for the people. So what a segue, surrender of your firearms. You have 24 hours to surrender a firearm upon service after the service of that order. And your options for surrender: you can sell those firearms to a dealer. Again, I said FFL a second ago. Some of you probably know what that means. Storage by the law enforcement agency is also a possibility. And there are some situations where you can transfer to a relative who does not live with a respondent, but that is limited to antiques, curios, or relics. And that is language coming from federal statute that basically says that those firearms, by and large, are not usable. So a usable firearm needs to go to law enforcement or a federal firearms licensee. If a person has a concealed carry weapons permit, or otherwise known as a concealed handgun permit, that must be surrendered as well. And if you are holding firearms and they belong to somebody else, if the respondent is holding firearms and they belong to somebody else, then those are removed, and the owner can get those back from law enforcement or the FFL if they agree to store the firearm in a manner to prevent possession by the respondent. With law enforcement, in that situation, you must request, the law enforcement officer must request immediate surrender of all firearms at the time of service. The respondent states a preference for surrender, and law enforcement agency keeps possession until those arrangements are made. So again, whether they go with the law enforcement in storage or with the firearm dealer. And that may have additional ramifications if there are other situations, such as let's say the person already has a felony and they have firearms again, they're very unlikely to be able to store those with a dealer because they shouldn't have them in the first place. That's very likely to lead to other criminal charges, in which case those firearms are not going to come back to you, at least until that's all cleared out. If a search warrant was not granted, the law enforcement asks if the respondent will voluntarily surrender any weapons. And if they do not voluntarily surrender them and there is no justification for a lawful search, then no firearms are seized. So let's just move right on then to court hearings.
Okay, so this slide is about the hearing that happens for the 364-day ERPO. So required in statute is that it has to be held within 14 days of the TERPO. And that doesn't mean it has to be exactly 14 days. So we have gotten cases set out even fewer than that. I've gotten 8 days to prepare, and we'll talk a little bit more about that at the end of this slide. At this hearing, the petitioner and the respondent can present evidence, they can cross-examine witnesses. It's truly adversarial, and kind of any evidence that you can sort of imagine bringing is available. The court considers the same factors as we discussed about the TERPO hearing. So all those things about if there's been credible threats and all those different things. The burden of proof is raised from the preponderance of the evidence to clear and convincing, which is that higher standard. And then if granted, the ERPO lasts 364 days. During that 364 days, the respondent is given one opportunity for a hearing to restore their rights prior to the expiration of the 364-day order. And they only are given that one ability. And at that hearing, the burden is shifted to them that they have to show that there are facts that have changed that would require them not to need to be under the order anymore. And then law enforcement can also, or any petitioner can also ask for an extension of the 364 days by filing an extension towards the end of the expiration of the first order. So they can last longer than 364, but it does require a full hearing again to justify the continuation of them. We did want to talk a little bit about just the short turnaround time of the 14 days. I think that this is a bigger impact even on respondent counsel than it is on the rest, than it is on me, but we did want to flag that as well.
Yeah, thanks, Allison. I would agree that this is a good place to kind of talk a little bit about that 14-day hearing requirement. There's often, when law enforcement and the city attorney is involved, there is quite a bit of data to go through in a discovery process, and it's very time consuming. It's in the past has at least been in some cases many gigabytes of information to go through. It's a lot to organize, and then to discover on respondents counsel's side what is missing to tell my client's story and my client's side of the evidence. Do I need to find witnesses that are willing to come? Do I need to subpoena witnesses to come to the hearing? Do I need to interview them ahead of time? Do I need to get additional information? Do I need to make records requests? And so the city attorney is certainly under a duty to try and be as cooperative as possible, but they are also very cooperative at letting the court process move forward as openly and transparently as possible. And so, you know, I've had some discovery packets come over from them within a few days, within a couple days of them even creating the data. And then it takes sometimes hours to get all of that downloaded off of the protected server that they have. You know, and so with those kind of considerations, I think that, you know, a respondent is going to do best to work with court-appointed counsel as closely as possible, because there isn't time to find private counsel. One thing that I think we do mention in this presentation is that a person has one chance in the next 364 days to motion for a termination of the order. So, you know, some of those back-end ideas like getting your own counsel, you know, really, potentially a panoply of other evidence like reviews and evaluations by doctors who already have a busy practice and might not be able to stop that practice right away. You might need to think about those as a secondary level of defense on these. And then working with counsel and trying to at least cover what you can in the first hearing is going to be really important. Did you have anything on that 14-day, Allison?
The only thing is that we have had some cases that have where the respondents have asked for a continuance. We, as the city, we haven't had to ever initiate a continuance for ourselves on the initial continuance. So some of the cases have been continued multiple times. And I think that there's consequences to doing that because it does extend the length that the order exists. But sometimes if a respondent does want to provide a certain kind of evidence, then it might be in their benefit to continue with the hearing. I think it's another thing that we're just not really sure what the legislature intended and how we can do some of these really extensive hearings in such a quick turnaround. And I think we've been trying to work together to figure out what the best process is, but haven't quite figured that out.
Absolutely agree with you on those points as well. Remember, it is a 364-day order when it enters. So if there is a continuance, any time you've continued has been tacked on to, will be end up ultimately being tacked on at the end. Yeah.
So kind of returning back to some of the things we talked about earlier with that there are substance and alcohol use disorder considerations in all of the ERPO findings that the court makes. So the court has to consider when they're making their findings, whether the respondent meets criteria for an emergency commitment for a drug or alcohol use disorder pursuant to Title 27. And the finding there is whether the person's incapacitated by their drug or alcohol use and or is a danger to himself or others due to their alcohol or substance use. And it can result in being held for a 5-day emergency commitment. And then ultimately, someone can petition for a longer 9-month involuntary commitment for a drug or alcohol treatment. And I think one of the things that makes that's difficult in this is that because it's an emergency commitment, prior to this legislation, those emergency commitments were only initiated by detox facilities themselves. And so it's really unclear in this legislation what the role of the court would be. Like, is the court supposed to initiate that emergency commitment on their own? And really, in a practical sense, it probably just means that the court is going to order someone to be transferred to a detox facility and evaluated there. But the meaning is really unclear, and the language in the statute's not very, it doesn't really provide a lot of clarity. And I think we've never done this in Denver. We haven't used this tool yet. And I really envision that we would only use it if an individual were to actually show up to court intoxicated. I think otherwise it really doesn't make sense to send a respondent to a detox facility if they're sober, regardless of whether or not they have these a substance use disorder. So we just don't really know how this fits into ERPOs yet. It's another thing we still kind of have to figure out.
So with mental health considerations, we are aware and actually keenly aware that this is not, an extreme risk protection order is not a mental health hearing. And you are not, it's improper to say that because there's a mental health disorder, the person should not have firearms. We do already have kind of a voluntary compliance at the state level with the federal Brady Handgun Violence Prevention Act, where if a person is committed to the Department of Human Services, if they are under a guardianship, an order for guardianship, or if they are under a court order for involuntary treatment for short-term or long-term certification, that they are automatically added to the National Instant Criminal Background Check System, which prevents them from having a firearm. This is a situation, these ERPO and turbo hearings are about substantial risk of personal injury to self or others. Nevertheless, if at the hearing, the ERPO hearing, the court shall consider at that hearing whether the respondent meets the standard for a court-ordered evaluation for persons with a mental health disorder. Under 2765-106, the court has authority to, the district court has authority to initiate an evaluation if it's an emergency, and they go through the procedures there in those statutes as to whether, and in this case, it's an evaluation, and they are either under that court order evaluated and released, or evaluated, and if there's enough there that a physician would believe that the individual has a mental health disorder and as a result of the disorder is essentially dangerous to self or others or disabled, then a 3-month certification can enter, would be filed with the court. I think we mentioned it earlier that in the TURPO proceeding, a person can file a petition for an evaluation, but I just want to point out that in the TURPO, the court isn't required to do any of that because it's an ex parte hearing. They wouldn't really be able to do that. If there are, the 2765-106 statute does use the words probable cause, and that's what the court will be looking for on a filing to order the person to be evaluated in an ex parte hearing. Or again, at the ERPO hearing, the court shall consider that person there in front of them and whether it should include an evaluation. One of the standards, though, that differ for ERPO versus the dangerousness element, whether danger to self or danger to others in mental health, is that for an evaluation to be required, commonly known as the M1 hold, there is a requiring of an imminent nature to the dangerousness. That is removed for the ERPO, and that One could pose a substantial risk in the near future in the TERPO, or just a substantial risk in the ERPO, and that would qualify for an ERPO where it wouldn't qualify for mental health hold and evaluation. Some of these finer details end up being pretty important in a person's life, though. So I guess then moving on to how do they fit within the overall system? I think we can.
Yeah.
Go ahead.
So I think kind of like what Jonathan already flagged, these proceedings, while they have implications on mental health and while they discuss mental health, they don't fit really cleanly in the mental health system, because they should just be about individuals with mental health issues, because there's lots of people who pose significant risks who would not be users of the mental health system. So ERPOs are kind of a tool to use to help people, but they really aren't going to be some sort of perfect solution to prevent gun violence. And in fact, as I'm sure you all know, individuals with mental illness are more likely to be a victim of violence than a perpetrator of violence. And I think one of the concerns with any legislation like this is that it gets linked too heavily to the association between mental health and violence. And I think that's something that we do want to be really careful about as people who operate in this world. The majority of the Denver Police Department's ERPO cases have been related to threats of self-harm rather than harm to others. So again, it really hasn't been something that's been focused on preventing violence against someone else. And the majority of cases, the individuals have also agreed to allow the extreme risk protection order to enter against them rather than going to a contested hearing. And I think in part that has to do with I think some individuals having the insight to recognize that individuals in their lives are worried about them, and that's why these ERPO proceedings started moving forward. And so I think some people have used it as an opportunity to decide that they don't want to challenge and go to an adversarial hearing potentially that involves some of their family members. But so the majority of our cases have consented, but I don't know if that's a statewide trend or more of just a Denver trend. And I think overall, what we've had conversations with Denver police is that a lot of the focus on violence prevention in general just needs to continue to be on prevention and mental health training for officers. And so the ERPO, while it is an effective tool, just really isn't going to be kind of a perfect solution to preventing gun violence generally. And I think the bill was really offered as a way they talked about in the hearings to talk about preventing mass shootings like the Aurora Theater shootings. It also was a big discussion about preventing what happened to Zachary Parrish in Douglas County, which is that he's a deputy that got shot while trying to put someone on a mental health hold. I think the result has really been more focused on harm to self. And so those aren't really the cases that are publicized as much, but I do think those are the individuals who we've typically been actually helping more. And then I think also, as Jonathan mentioned, there is already existing law about individuals who are placed on mental health certifications, as well as involuntary commitments, that they are under the federal law prohibited from shipping, transporting, receiving, or possessing firearms or ammunition. So I think ERPOs in that sense might also be kind of a belt and suspenders solution. There's not really any reason to add on another layer of protection if there is already a federal law that prevents certain individuals from having firearms.
So quickly here, we have a couple minutes left, maybe a couple lessons learned. One thing that I learned from the city, Allison, you were telling me that police don't have access to the federal no-buy list, the NICS list we were just talking about, unless some limited circumstances exist. What are those?
Yeah, so they're only allowed to search that database when somebody shows up to the Property Bureau to recover a firearm that was taken from them by police. And that's the only time. So a regular street officer won't know if someone's on the no-buy list when they're interacting with that individual. So it really makes it so that there's not really an enforcement mechanism to ensure that individuals who aren't supposed to have guns don't have them. There's no one following up really with them. There's not a ton of way to actually enforce that. And in fact, if somebody were to want to press charges against someone, like they had a firearm and they're not supposed to, It's a violation of federal law, and the Alcohol and Tobacco and Firearms Bureau would be the individuals prosecuting it. And in 2017, they received 100,000 referrals and only prosecuted 12 individuals. So we're not really talking about a gun control law that's utilized in any significant way to prevent individuals from having firearms.
We also know that Colorado's General Assembly did adequately predict the number of RPO cases, but I would say a significant failure to attack a fiscal note on recognizing how resource intensive they are. We've talked about the 14 days that court-appointed counsel has to do the work, and that it's basically a showstopper for that attorney to become effective. And a person is certainly afforded the effective assistance of counsel by this statute, or at least I would argue that pretty clearly. And so then we know that there may be inadequate ability for an attorney to subpoena, to hire witnesses, to get an evaluation for someone in the way that is typically done through other methods. And then modification and termination and renewal hearings were not taken into account under that as well, and whether the attorney remains of counsel or of record or not. So good lessons there. It will likely need to be tweaked, and they will likely want to hear from the people who've been practicing in that, as well as take a good close look at the data that it provides. Thank you so much, Allison, for joining us, and good luck to everyone. Enjoy the rest of the day and the show this evening, and thank you so much for being a part of the NAMI family today.
Yeah, thank you.